Hearing will come to order. Today we have 5 judicial nominees. Eunice Lee, nominated to the Second Circuit, Veronica Rossman to the 10th, 3 nominees to the Western District of Washington, Judge David Estudillo, Lauren King, Tana Lynn. Several of our colleagues will formally introduce the nominees. I'd like to make a few observations before we start. First, with these 5 nominees, the Biden administration and Senate Democrats continue to strive for professional balance on the bench across America. Today's slate includes, for example, 2 federal public defenders, a former immigration attorney, an expert in tribal law, and a civil rights champion. I will concede that historically there are many former prosecutors who ascend to the bench, and many of them do an extraordinary job, so it's no reflection on their backgrounds, what I'm about to say. But we need in our judiciary a reflection of America across the board, demographics and professional experience. To date, federal judges have come from that narrower pool of professional backgrounds, which I've said, nothing wrong with that. They make great contributions to justice in America. But we want to see if we can bring diversity to the bench across America, and I think that's a good goal. Consider how many active circuit court judges have experience as federal prosecutors. Active circuit court judges in the federal system, 48. How many have experience serving as public defenders across America? 2. The numbers are even more stark when it comes to the Second and 10th Circuits, where 50% of the active circuit court judges have federal prosecutorial experience and not one as a federal public defender. I'm pleased to see efforts now underway to address this imbalance, including the nominations of Ms. Lee and Ms. Rossman to the 2nd and 10th Circuits, respectively. My second observation is to note a fact that has been raised many times by my Republican colleagues in previous meetings, and that is about an organization known as Demand Justice. To my knowledge, Demand Justice has no role in choosing judicial nominees, and certainly the group has no special influence over me. They've taken after me from time to time, which is their right. Moreover, it's critically important to look at who actually is driving the judicial selection process in this administration. The answer is simple: the President and the United States Senate. Think about the 5 nominees before us today. They've been recommended by and have the strong support of their home state senators. They were vetted and nominated by the White House. Compare that to the role in previous Congress, where the Federalist Society played an outsized role in selecting nominees. Then candidate Trump said in a radio interview in 2016, and I quote, "We're going to have great judges, conservative, all picked by the Federalist Society." And then White House counsel Don McGahn boasted in 2017 about the prominence of the Federalist Society in choosing Trump's judicial nominees. It's quite ironic that those who acquiesced or even supported the Federalist Society's determinative role in picking judges now have overstated the role of another organization, Demand Justice. My third observation is this: we should not expect to require every judicial nominee coming before this committee to ascribe to originalism as their judicial philosophy. As my friend Lori Lightfoot, the mayor of Chicago, pointed out, there's a very good reason why support for originalism should not be a litmus test. This is what she said last year, and I quote, "You ask a gay black woman if she's an originalist? No, ma'am, I'm not. That Constitution didn't consider me a person in any way, shape, or form because I was a woman, because I am black, and because I am gay. I'm not an originalist." So said the mayor of Chicago. She continued, and I quote, "Originalists say, let us go back to 1776, and whatever was there in the original language, that's it. That language excluded, incidentally," she said, "over 50% of the people living in America today." So the mayor went on to say, "I'm not an originalist." She's rather outspoken, as you noticed. Our most important lodestar should be whether nominees before us have the hallmarks of what makes a good judge. Independent? Can they set aside personal beliefs and leave partisan politics in the robing room? Will they apply the law to the facts? Will they approach every case in a fair-minded way? I firmly believe we can answer yes to these questions for each of these nominees before the committee today. And with that, I turn to my friend and ranking member, Chuck Grassley.
I think any originalist would admit that you take into consideration all the constitutional amendments, 27 or 28 of them, that's been added to the Constitution. Today, we're here to congratulate the nominees and to hear from 5 of them, 2 for the circuit, 3 for the district. I want to thank Chairman Durbin for following standard practice of dropping a district court nominee from the second panel when putting 2 circuit nominees on the first panel. The 2 circuit nominees continue President Biden's trend of nominating criminal defense judges. Both are federal defenders, one in Colorado, the other in New York. I've said repeatedly why we need to evaluate such nominees carefully, both because of how Democrats looked at Trump nominees and because of what liberal activists say about how these defense judges will behave on the bench. I want to go into all that. I'm not going to go into all that again because I spoke to that in a previous circuit nominees before us, but my concerns still apply. I think this trend also presents other problems. A circuit judge needs to be a generalist. Criminal defense lawyers aren't going to be criminal defense judges. They'll be hearing every kind of federal appeal. We need to make sure that they're ready to do just that job. Ms. Rossman, the nominee for the 10th Circuit, is a federal defender in Colorado and Wyoming. She would replace Judge Carlos Lucero, who was first and only Hispanic judge on the 10th Circuit. While Ms. Rossman may bring the diverse experience of being a criminal defense lawyer, I want to know if she has the kind of deep diversity of experience that we saw in Trump's 10th Circuit nominees. Judge Joel Carson, for example, was a criminal defense lawyer as well, but he also had experience in oil and gas, employment law, land use, and commercial litigation. Judge Allison Ide had significant experience in Indian law, constitutional law, employment law, criminal law, and civil litigation. And she did it all from the perspective of a government lawyer, a private lawyer, a legal academic, and a state judge. I want to ask Ms. Rossman about her other legal experiences beyond being a criminal defense lawyer. It's a similar situation with Ms. Lee. She has spent her career specialized in criminal appeals in state and federal courts. I'm sure that will bring a diverse perspective on criminal matters, but what about the rest of the court's docket? Michael Park brought the perspective of being a civil rights lawyer fighting to end racial discrimination in college admissions, but he also had experience in a broader constitutional law, environmental law, and banking. He did this in big firms, small firms, and within the Justice Department. Likewise, Judge Stevens Menashe, the first Iraqi American on the Second Circuit, brought the important perspective of a legal academic and executive branch official while also having wide experience in issues beyond constitutional law like antitrust, securities regulation, and products liability. In many ways, the Second Circuit is a commercial circuit. What background will Ms. Lee bring to that aspect of the job? As for the district court, we have 3 nominees for the Western District of Washington. There are 7 authorized judgeships for that court and currently only 2 judges. That's because of the blue slip policy. Neither Chairman Graham nor I contemplated doing anything to pressure our colleagues from Washington on the district court, even though it was being kept empty. As far as we were concerned, that was between those senators and the White House. As to the nominee, Judge Estudillo brings an interesting perspective from Eastern Washington, what he has called East Washington values. And Ms. King seems well respected in the bar. Ms. Lynn seems to have been very involved with so-called legal resistance during the Trump years. I expect to have questions about that for her to answer. Thank you, Mr. Chairman.
Make sure I get the proper starting point here. We have a number of colleagues who are going to join us this morning to introduce several of the nominees. I was thinking the majority leader.
He's still on his way. He's on his way, so we'll start with
On his way? Well, then we're going to reward early attendance by the junior senator from the state of New York, Senator Gillibrand.
Thank you, Mr. Chairman. Chairman Durbin, Ranking Member Grassley, and members of the Judiciary Committee, it's my honor to join you today to introduce Eunice Lee, nominee to be judge on the Second Circuit Court of Appeals. Ms. Lee grew up in a military family and saw the importance of public service from an early age. That commitment to serving your community and protecting the rights of others has been a cornerstone of her legal career, which she has spent in service to those most in need. Following her graduation from Yale Law School and clerkships in both the Southern District of Ohio and the Sixth Circuit Court of Appeals, she joined the Office of Appellate Defender in New York City. During her 20 years at the Office of the Appellate Defender, Ms. Lee served as a supervising attorney and represented clients who were in great need of legal assistance but could not afford representation. She dedicated her practice to ensuring that everyone interacting in our legal system, regardless of their financial circumstances, was able to be heard. In 2019, Ms. Lee joined the Federal Defenders of New York, where she has advocated on behalf of her appellate clients throughout the sentencing process by developing and presenting a full picture of their lives that is not exclusively defined by their mistakes. Throughout her career, Ms. Lee has represented more than 380 indigent clients in proceedings before state and federal appellate courts on direct appeal, in post-judgment motions, and in habeas proceedings. Working on those cases gave her an acute awareness of the awesome power of our judicial system. She fundamentally understands the staggering effects that the laws can have on people's lives and its disproportionate impact on low-income individuals convicted of crimes. Her clients are people who desperately are relying on the promise of fairness from the legal system, and she's fought to deliver on that promise throughout her professional life. She's uniquely positioned to bring a critically important perspective to the bench and to the Second Circuit. If confirmed, Ms. Lee would be the first and only judge on the circuit with experience as a public woman to serve on the circuit's bench. Her recognition that every decision has far-reaching effects and her commitment to fairness throughout the entire legal process, regardless of the outcome for individual clients, will be among her greatest strengths as a judge. Her approach to the law will ensure that all who come before the court are given the chance to be heard. And her voice and her experience will bring an important and much-needed new perspective to the bench. I now defer to my senior senator.
We'd like to welcome Senator Schumer back to the Senate Judiciary Committee. Senator?
Well, thank you, Mr. Chairman. It's good to be back at the Judiciary Committee. I spent many, many years, actually, between my House and Senate service. I got on the Judiciary Committee in 1982 in the House, was on the Judiciary Committee from the very beginning in 1999 when I got to the Senate, so I miss you all very much. But I'm glad to be here on this auspicious occasion. I'm glad to be here with Senator Gillibrand and Senator Bennett. And I have the pleasure to introduce Eunice Lee. She's an incredible public servant to be nominated for the Second Circuit Court of Appeals, where she will succeed the great Judge Robert Katzman, who we pray for. He's ailing right now, a model public servant who took senior status this year after more than 2 decades on the Second Circuit. Ms. Lee is the daughter of an Air Force veteran. Thank you for your service, sir. Born on base in West Germany, Ms. Lee is a first-generation college student who graduated summa cum laude from Ohio State before receiving her J.D. from Yale Law School. Beyond that, she hasn't taken the typical path to the seat she now occupies, a nominee for the Second Circuit, which we in New York believe is the most important circuit court. Some don't, but we do. D.C. is very important, and they all are, but we love the Second Circuit. Ms. Lee is not a former prosecutor or a product of a big corporate law firm. Instead, Ms. Lee spent her entire career in public service, dedicating herself to representing those criminal defendants who cannot afford counsel. If confirmed, she would be the only federal defender among the Second Circuit's active judges, the only one. And let me take a note here, Mr. Chairman. I recommended her to President Biden, and not only because she was outstanding, but because we want to bring a great diversity of experience as well as other reasons for diversity, racial and religious and LGBTQ, et cetera. But we want experience diversity. And I have been proud now to ask two people to join the Second Circuit and ask President Biden to nominate them, Ms. Lee, and now, of course, a second nominee who was the leading voting rights defender from the Brennan Institute, Ms. Perez, Myrna Perez. And so we're changing who sits on the bench. It's not just going to be partners in fancy law firms or prosecutors, but people who have that diverse experience. And Ms. Lee personifies not only excellence as a lawyer, but that diverse experience. She's currently a member of the Federal Defenders. She has spent more than 2 decades in the Office of the Appellate Defender in New York. She's represented over 400 indigent clients on direct appeal and in post-conviction proceedings, as well as in federal habeas corpus petitions. She has argued cases both at the state level and before the Second Circuit. And over the course of her career, Ms. Lee has helped defendants receive fairer sentences, get fairer treatment during incarceration, make sure their constitutional right to counsel was not infringed. You know, we've all heard those words in the Miranda warning. You have the right to an attorney. If you cannot afford an attorney, one will be provided to you. It's one of those fundamental rights we have here in a democratic society, our great democratic society. And it's along with the Fifth Amendment that it's vital to the fairness of our judicial system. But it takes dedicated public servants, lawyers willing to work longer hours for lower pay, in American courtrooms every day. That's Ms. Lee, someone who has dedicated her career to making sure that equal justice under law is faithfully applied for the impoverished as well as the privileged. Eunice Lee would bring a unique breath of fresh air to the federal bench that has sorely lacked the perspective of lawyers like her. And I just want to say to Ms. Lee and to the audience here, she will not be the only person from this type of background. There will be many more. I mentioned Myrna Perez, Dale Ho. I just suggested President Biden nominate him to the Southern District of New York. He's the leading voting rights lawyer of the ACLU, and there will be many more. The bench will be filled with appointments who will restore the balance that we believe has shifted way over to the hard right during the Trump years, but it will also shift in terms of experience and represent much more of America than it had represented in the past under our Democratic majority and under President Biden. So let me just conclude again with some of Ms. Lee's great qualifications. She's been described by her colleagues as a brilliant advocate, a first-rate legal writer, a natural teacher, and a mentor. She's also been an adjunct professor at New York University, and her clinic on criminal appellate advocacy, which she designed herself, is one of the courses in highest demand at the law school. And when I met with her, I saw for myself the breadth of her knowledge, but also her measured, judicious approach to the law. So she combines that experience with the understanding that you always have to try to walk in someone else's shoes. Just this week, a group of over 70 former New York federal prosecutors, the folks who often found themselves on the opposite side of Ms. Lee, called her a brilliant, accomplished advocate who's supremely well qualified to serve on the bench. Again, those were the folks who came up against Ms. Lee, urging the committee to confirm her. I can't think of a higher compliment. The committee should also be aware that if confirmed, Ms. Lee would break another barrier. She would become the second African-American woman to ever sit on the Second Circuit. After 4 years of confirming nominees that were predominantly male and predominantly white, we have a lot of work to do to make sure the federal judiciary reflects the diversity of our nation. As the senator from New York, as I mentioned, as well as the Senate Majority Leader, it's my intent to recommend and work to confirm judges who would bring both demographic but also professional diversity to the bench. Expanding the range of experiences and perspectives on the bench strengthens the public's trust in our judiciary system and strengthens the court's ability to apply the law fairly, impartially. Ms. Lee's confirmation would do precisely that for the prestigious and important Second Circuit Court of Appeals. She carries my fervent and strongest recommendation. Thank you, Mr. Chairman, and it's good to see you as Mr. Chairman over there.
Thank you, Senator Schumer. We know you have a busy schedule and appreciate your coming by to introduce the nominee. And Senator Gillibrand, thank you as well. Senator Bennett.
Thank you, Mr. Chairman, for having me today, and to the ranking member, Senator Grassley, thank you very much for holding this hearing and for inviting me to introduce Veronica Rossman, President Biden's nominee for the U.S. Court of Appeals for the 10th Circuit, the most important circuit in the United States of America. Before I begin, I want to welcome her husband, Ken, and her daughter, Sophie, who join us today. Thank you guys for making the trip to Washington. I also want to say a word of thanks to Carlos Lucero, who held this seat before this nomination, who served the 10th Circuit and our country with such extraordinary distinction. Thank you to him and to his family. Ms. Rossman comes to this committee with broad legal experience and a sterling reputation in Colorado. Ms. Rossman cares deeply about justice and the rule of law because she knows what it means to live without them. Mr. Chairman, Veronica was born in Russia, where her family faced anti-Semitism at every turn. Her grandparents couldn't openly practice their faith because they feared retaliation at work. Her father was a brilliant cancer scientist, but he was who's a pianist and music teacher, never openly shared her faith, and the family fled Russia. Veronica was a child at the time, and she came, like so many other people, to America as a political refugee. And from virtually nothing, she built a distinguished legal career. After earning her BA from Columbia and JD from the University of California, Hastings, she clerked for the Nevada Supreme Court. She then practiced appellate litigation at Morrison and Forster, where she worked on some of the largest international patent cases in history. Later, she served as a staff attorney for the U.S. Court of Appeals for the Ninth Circuit and taught law at the University of Denver. At this point, Veronica could have pursued any number of high-paying legal jobs. Instead, she became a federal public defender for the districts of Colorado and Wyoming. And over the past 12 years, Ms. Rossman developed rare expertise as an appellate specialist, handling direct criminal appeals from every judicial district in the 10th Circuit. She also represented more than 250 indigent clients, Mr. Chairman, from controversial defendants to people sentenced to lengthy terms for a nonviolent offense despite having no criminal history. She fought for every one of those Americans, often against the longest odds. More than that, she fought for the American ideal that everyone deserves equal justice under the law. If confirmed, Veronica would be the only judge on the 10th Circuit with experience as a public defender. We need more judges like Veronica who are not only highly qualified, but who know what it means to be on the wrong end of the legal system that too often fails the most vulnerable in our society. Ms. Rossman's qualifications are unparalleled. She's been a first-rate lawyer, and she would make an outstanding judge. I urge the committee to approve this outstanding nominee. Thank you, Mr. Chairman.
Thank you, Senator Bennett. And concluding the Circuit Court nominees, we have Senator Hickenlooper. I hope he's available to us.
Yes, I am. I'm on the video, and I apologize. Can you hear me?
We can hear you loud and clear. Proceed.
Great. I apologize for not being there in person, but thank you, Chairman Durbin and Ranking Member Grassley, for inviting me to share a few words about Veronica Rossman, President Biden's nominee to serve on the 10th Circuit Court of Appeals. Senator Bennett did an excellent job of summing up her background, coming over from Russia as a political and religious refugee, having dealt with anti-Semitism for much of her early life, and then working through that and being able to go graduate from Columbia, get a law degree from Berkeley, from Hastings College at Berkeley. I think that what I'd like to emphasize is her commitment to trying to deal with those most difficult cases. She really is a seasoned practitioner. 95% of her practice has taken place in federal courts. And in that time as a public defender, she's personally handled and supervised over 100 criminal appellate matters arising out of, as Michael said, every judicial district in the 10th Circuit. In private practice, she's specialized in these numerous complex civil litigation cases, including appellate cases and a number of matters involving antitrust law and intellectual property. Ms. Rossman, in dedicating her life and the majority of her career in the legal practice to serving the office of the federal public defender for the districts of Colorado and Wyoming, she brings that perspective that I think too often is missing from the bench, an understanding of the real world impact of sentencing decisions and disparities. And I think she will bring a significant new perspective to how decisions are made on this Court of Appeals. Over the course of her career, Veronica's earned a reputation for being not only fair, but being tenacious and really dedicated to equal justice under the law. I think she is well respected. I can't tell you how strong her recommendation from peers and colleagues, but included many of those who have served as opposing counsel on cases where she's worked. I have absolutely no doubt that Veronica will serve with impartiality, with honesty, and with integrity. And so I enthusiastically support Senator Bennett's recommendation that this committee will approve her nomination, that the Senate will act swiftly to confirm her. Thank you, Chairman Durbin and Ranking Member Grassley, and every member of the committee for your consideration and hopefully approval and confirmation of this outstanding nominee. Thank you.
Thanks, Senator Hickenlooper. Yesterday on the floor of the Senate, Senator Murray told me how excited she and Senator Cantwell were about the three nominees she's about to introduce. Senator Cantwell, unfortunately, can't be here in person, but has sent a letter of support. I now turn to Senator Murray for a formal introduction of those nominees.
Well, thank you, Chairman Durbin and Ranking Member Grassley. It is really my honor, and I am excited to introduce you to three nominees for federal district court vacancies in the Western District of Washington. As this committee knows, Washington State has had these vacancies open for a number of years, so let me start by thanking President Biden and this Judiciary Committee for working so quickly to provide some long-awaited reinforcements to our bench in Seattle and Tacoma. In addition, I especially want to thank our nonpartisan Judicial Merit Selection Committee comprised of 10 Washington State lawyers and co-chaired by Ian Warner and Rob McKenna, who guided us in selecting these highly qualified nominees that are before you today. I will introduce them alphabetically. First, I would like to introduce Judge David Estudillo. He is here today with his family, his wife Sandra, and 3 children, Sophia, Sarah, and Sebastian. Judge Estudillo currently serves as a Grant County Superior Court judge and has a distinguished career as a litigator and immigration attorney before his current role as the presiding judge of the Grant County Superior Court. He is a graduate of the University of Washington School of Law and is a Washington State native whose parents came to the United States from Mexico through the Lucero program in the 1960s. Throughout his career, Judge Estudillo has consistently provided pro bono services and legal education to Latino communities across Washington State, helping people to better understand immigration policy and procedure at community forums. Judge Estudillo works hard to ensure that every person who enters his courtroom is treated with respect and dignity. I know he will bring that same approach to the federal bench in Tacoma and is well prepared to serve as a federal district court judge. Turning to Ms. Tana Lynn, Ms. Lynn is today here with her family, her husband Paul Michael Holland, her son Patrick, and her daughter Julia. Ms. Lynn is a litigator with Keller Rohrbach in Seattle, where she practices in the complex litigation group. Her career has been dedicated to serving the public, having served as president of the board of directors of the ACLU of Washington, as a public defender for the District of Columbia, a trial attorney with the Civil Rights Division at the Department of Justice, and as an attorney with the Michigan Poverty Law Program. Ms. Lynn has consistently sought opportunities to help train the next generation of lawyers, having also served as an adjunct professor for Seattle University School of Law and developing trainings for the National Institute for Trial Advocacy and National Legal Aid and Defenders Association. Ms. Lynn would also make history if confirmed. She would be the first Asian American federal judge in Washington State history. A Chinese American, Ms. Lynn immigrated from Taiwan with her family when she was a child. She would strive to run a courtroom where all litigants are seen, heard, and treated fairly. I wholeheartedly support her nomination. Finally, turning to Ms. Lauren King. Ms. King is here today with her father, Jeff, her mother, Lisa, and her fiance, Sean. Ms. King currently chairs Foster Garvey's Native American Law Practice Group and has served as a pro tem appellate judge for the Northwest Intertribal Court System. She has served as a commissioner on the Washington State Gambling Commission and taught federal Indian law at Seattle University School of Law. Ms. King is a citizen of the Muskogee Nation, and she would make history by being the first Native American federal judge in Washington State. She would join only 2 other currently serving Native American federal judges and become the 5th. Washington State is home to 29 federally recognized Indian tribes, and it is absolutely essential that federal judges better reflect and understand the unique histories of Natives people and the legal principles that protect and preserve Native American standing under federal law. Ms. King will bring important experience and a critical perspective to the federal bench. Mr. Chairman, I'm extraordinarily proud of these 3 nominees before the committee today. They represent the best of Washington State and their country. It is my honor to submit their names to President Biden, and I hope all the members of this committee will join me in supporting these 3 highly qualified nominees. Thank you.
Thank you very much, Senator Murray. We appreciate that. And as I mentioned, Senator Cantwell's letter of support was made official part of the record. We're going to change over the table to accept the first panel of Circuit Court nominees. So if you'll just bear with us for a moment, we'll stand at ease. If the 2 nominees would come to the table, please. If they'll remain standing for a moment, I'll administer the oath. Please raise your right hand. Do you affirm the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that the witnesses answered in the affirmative and that we have had a conversation here during this brief recess of correcting the record so that Ms. Lee's College of Undergraduate Work is officially noted as the Ohio State University in the record.
Thank you.
And now I give each of you an opportunity to make an opening statement. Ms. Lee.
Thank you, Chairman Durbin, Ranking Member Grassley, and all of the members of the committee for inviting me to appear today and for considering my nomination. I would also like to thank my home state senators, Majority Leader Schumer and Senator Gillibrand, for their very kind and warm introductions of me. I'd also like to thank President Biden for nominating me to fill the seat currently held by Judge Robert Katzman. Judge Katzman is a very distinguished and well-regarded judge on the Second Circuit, and he's someone whom I respect very much. I have with me today 4 family members who came to support me. They traveled here by car from Columbus, Ohio. They are my parents, John and Irma Lee, and my brother and sister-in-law, Eric and Noelle Lee. My sister, Edith Webster, who is a public school teacher in Rockford, Illinois, could not be here today because school is not quite out yet, but she's cheering me on as well. And I also have many extended family members from around the country who are supporting me and watching at home. I appreciate the support from all of my family members, but I would just like to take one moment to express particular gratitude to my parents who are with me today. During this period of going through this process and receiving this incredible honor and this incredible opportunity has made me think a lot about my parents and their opportunities and what they've experienced. Both of my parents grew up poor in small-town Arkansas with very limited opportunities. When my father joined the Air Force, it was with the hope that they could have a better life for them and for their family. And my siblings and I have benefited greatly from the many sacrifices that my parents have made for both of us, for all of us, during their lives. And I'm truly appreciative of that, and I feel truly blessed to have them in my life. And I feel very confident that I would not be here today without their love and support. And then lastly, I would like to also thank my friends and present and former coworkers who've also been incredibly supportive throughout. And so I'd like to thank them as well. And so again, thank you to the committee for having me appear today, and I welcome your questions.
Thanks, Ms. Lee. Ms. Rossman? I think the microphone is not turned on. I think if you slide your thumb across it might work.
Seem to get it.
There you are, I think. No. Believe me, we struggle with these mics all the time, so it's not unusual.
Thank you.
Thanks, Mike. Senator Lee, thank you very much.
Thank you. Sorry about that. Thank you, Chairman Durbin and Ranking Member Grassley, and thank you to all the members of the committee for your time this morning. I'd like to thank President Biden for the honor of this nomination, and thank you to Senators Bennett and Hickenlooper for their support and their generous words this morning. I'd like to acknowledge the Honorable Carlos Lucero, senior judge now, who has ably served the 10th Circuit Court of Appeals since 1995. Judge Lucero is an exemplary jurist and a role model for all of us in Colorado and in the 10th Circuit. I'd like to introduce some members of my family, beginning with 2 very important people who were unable to travel here today, my parents. my father, Michael Ilyich Parkansky, and my mother, Zoya Yosifna Parkansky. My parents and I came to the United States from the former Soviet Union in the mid-1970s. We were refugees. Like so many immigrants to our great nation, my parents left behind all that they knew to build a better life in the United States. I still remember the day that we became citizens. I was in middle school. My parents led by example and instilled in me values I hold dear today: hard work, perseverance, integrity, and generosity. I want to thank them for their unwavering love and support and for the many sacrifices they made for me. Given how our American story began, it is beyond any of our wildest dreams that I would be sitting here today. Next, I'd like to introduce my husband and daughter, who are seated just behind me. Kenneth Fisher Rossman IV is a wonderful husband, father, and a brilliant lawyer. Our daughter, Sophia Rebecca Rossman, just graduated high school last week and will be starting college in California this fall. Sophie, you are my greatest inspiration. Thanks to my many other family members and dear friends throughout the country who are watching this hearing and supporting me. Finally, I would like to acknowledge the head of my office, Virginia Grady, for encouraging me to pursue this incredible opportunity. And to all my wonderful colleagues in Colorado and Wyoming, my sincere thanks. I am so grateful to appear before you today, and I will do my very best to answer your questions.
Thanks very much, Ms. Rossman. We'll do a round of questions here from the senators in attendance. And let me start. I'm not going to question your backgrounds and experience. They are extensive and impressive. There's no point in repeating for the record what has been already said about what you have done with your lives and the time that you spent in professional service to the cause of justice. I'm going to ask a more general softball type question just to ask you to reflect for a moment. At any moment in American history, if we had this hearing, we could certainly say we still face challenges in the United States when it comes to justice based on race, gender, poverty, religious belief, ethnic background. It still is a problem that haunts us. You've seen that in real time in your practice of law. Would you comment on the present state of the national debate on this issue of justice, Ms. Lee?
Thank you, Chairman. I think one of the critical issues relating to justice, one of the critical concerns, is the idea of equal access to justice, equal access to competent counsel in particular. One of the reasons that in my participated in a lot of training programs with other attorneys is the idea that not only is it important that people have access to counsel, but that the counsel that they have be competent and able to vigorously argue their positions. Part of the calculus of justice is one important part is, of course, a fair and neutral decision maker, but also parties to vigorously pursue the claims. And so I think between the issues of access to the courts, representation, fair decision makers, all of those are necessary to achieving justice, because the process is the thing that we have. We can't guarantee outcomes. We can't rely on assumptions about what's going to happen. We have to have a fair and equitable process. And so with those in place, with that kind of process, there can be a measure of justice regardless of the outcome. And so I think that, again, the question of access is something I think that's really important to address in our current system.
Thank you. Ms. Rossman?
Thank you. I would echo what Ms. Lee just said and simply add that in my role as an appellate federal public defender, one thing that I have witnessed that has really stayed with me is the importance of appellate courts in the lives of ordinary people. People come to the appellate courts wanting to be heard, wanting for the judges to be impartial, neutral, receptive in the sense of not an outcome determinative way in every case, but knowing they're going to get a fair hearing before the court. And I see that in the 10th Circuit. with judges who are open-minded and receptive. And I think that is very significant to ordinary Americans in terms of how people understand the judiciary, that they will get a fair day in court with impartial, neutral decision makers.
Ms. Rossman, let me be specific on one area. I noticed that you've devoted a significant portion of last year raising the alarm about the spread of COVID-19 among our federal prison inmates. Senator Grassley and I have joined in asking of the head of the Bureau of Prisons a year ago what plans were being made for this looming pandemic and crisis. And we were told at the time not to worry, things were under control. There were only 3 cases when it came to inmates and 3 cases when it came to staff. Well, we know what happened afterwards, unfortunately. Many hundreds died in our prisons. The rate of infection was 6 times what it was with the general population. And we still have genuine concerns and issues such as compassionate release being debated. Tell us a little bit about your background with this issue.
Thank you. The First Step Act, which this body has passed, is incredibly significant legislation. My work specifically in the last year has focused on the so-called compassionate release portion of the act, which amended the statute that allowed, that previously only allowed the director of the Bureau of Prisons to seek compassionate release for inmates, and changed the law in a way to allow inmates, if they exhausted their claims appropriately, to pursue relief directly with the court. That change was significant, and what we saw during the pandemic is a true crisis with individuals who were experiencing COVID within the prison system. All actors, in my view, were doing their very best under extraordinarily difficult circumstances. But the availability of relief for eligible individuals, certainly not for everyone, but for our eligible clients, was an incredibly important avenue to pursue.
Thank you. Senator Grassley.
Ask you questions. I assume your family fleeing Russia, that the names of Sakharov and Sharansky are important heroes for you. Would that be fair for me to conclude?
Sure.
Okay. Because they suffered a lot for the work of the people that we call refuseniks. You have a lot of experience when it comes to criminal appeals. In 2019, the 10th Circuit had 368 total criminal appeals compared to 1,135 civil appeals. There are over 150 appeals under diversity of citizenship alone, to say nothing of the appeals involving contracts, labor, torts, environment, tax, Social Security, and even marine injury. You know where I'm coming from. So what's your experience that makes it you a good fit for the generalist docket of the 10th Circuit?
Thank you for that question, Senator. I have been an attorney now for over 20 years and have had a variety of different types of legal experience. In addition to clerking for the Nevada Supreme Court and serving as a staff attorney for the Ninth Circuit Court of Appeals, my training ground was in civil litigation at a large law firm. I benefited tremendously from that experience. In my role as a litigation associate, I worked on cases involving a wide range of civil subject matter areas, specifically antitrust law, intellectual property law, contracts law, business litigation, things like that. Now, this was certainly a long time ago, as I've spent the last 11 years at the Federal Public Defender's Office. But I consider the work that I have done before as accessible to me. I think that if I were so fortunate as to be confirmed and a case came before me involving an area of civil litigation, that I would approach it diligently, get back up to speed on areas that I think I could access readily. And because I have spent the last decade, as I call it, at home in the 10th Circuit, practicing appellate litigation in the 10th Circuit, I would be able to hit the ground running in the sense that I'm very familiar with the structure within which these various appeals in a large range of subject areas would arise. And I'm confident that if confirmed, I could rise to the challenge.
Thank you for that answer. I think the next answer you can give me a short answer to. You have an impressive family story of fleeing the Soviet Union when you were a child. I'd like to read to you something another nominee whose family fled communism, Judge Barbara Lagoa, had to say, quote, "If we are not bound by what the Constitution means, then we are no different from the country my parents fled, Cuba, because Cuba has a Constitution and a Bill of Rights, and it means nothing because there is no one to say this is what the definition of the Constitution means if it's always ever changing," end of quote. In your words, a fixed meaning Constitution helps prevent tyranny. Do you agree with Judge Lagoa on this?
Thank you for that question, Senator. I'm not familiar with his remarks other than what you just read. I have a deep abiding love and respect for our Constitution and our democratic system, largely born of my experience as a political refugee, but also with my experience as a practicing lawyer, especially in the criminal justice area. The Constitution is an enduring document, and it is amazing in its ability to adapt over the years in countless Supreme Court decisions that have interpreted it. But I believe the Constitution is an enduring document.
One question for Ms. Lee. You've been a public defender for nearly your entire career. According to your questionnaire, you have no civil litigation experience. In 2019, the Second Circuit had 660 criminal appeals compared to 2,294 civil appeals. To pick a few examples, there are almost 300 appeals in diversity, over 200 in labor and employment, and well over 100 in intellectual property, securities, and antitrust. This court's grab bag category of all other civil appeals is among the biggest in the federal court system. What's your experience that makes you fit out of the second court?
Thank you for the question, Ranking Member Grassley. Certainly my practice has not been specifically in those civil areas. However, over the course of my career as an appellate litigator, I have often been confronted with topics and subject areas with which I'm not familiar. And certainly the experience of having to learn new topics in the context of a specific case is something I'm very familiar with. I've also had the occasion of, for many years, I was practicing in state court, and making this switch from state law to federal law as well was a change. And I think as an appellate attorney and as an appellate judge, should I be confirmed, you're presented with very discrete claims one at a time. And I have, as I said, a lot of experience learning new issues and figuring out how to address the law that applies to a particular case. Certainly I have, as I said, no specific experience in most of those topics that you raised, but I am very confident in my ability to get up to speed and to handle the cases that come before me.
Thank you, Mr. Chairman.
Thanks, Senator Grassley. Senator Lee.
Thank you very much, Mr. Chairman. Ms. Lee, after Justice Thomas's 1991 confirmation hearing, in a letter to the editor of the Ohio State Lantern, you made the assertion that Justice Thomas, as a black conservative, subscribed to the view that racism isn't an obstacle to success. With this ill-conceived assumption, which is a view that, by the way, I've never heard Justice Thomas express or espouse, You proceeded to criticize Justice Thomas's identification of his confirmation hearing as a high-tech lynching. In your words, you said, quote, "When it would make Thomas look better and garner sympathy, he was willing to acknowledge that there is racism and that it is an obstacle for millions of other blacks," close quote. And then in concluding your remarks, you added the following, quote, "I might stop short of calling Thomas a hypocrite, but I'm reminded of the saying that there are no atheists in foxholes. Perhaps you can also say that there are no black conservatives when in the political hot seat." First of all, what did that mean? I've got some follow-up questions about that, but tell me what that means.
Thank you for the question, Senator. First, I would note that the letter that I wrote as a 20-year-old college student 30 years ago does not reflect the views that I have today. And with regard to the nature of the letter, as I said, I was a student in college, a political science major, and the confirmation hearings were something that we talked about in classes. And that's something, the views I expressed at that time were the beliefs that I held. But in the time, in the 30 years since then, certainly I have learned and matured and interacted with clients and lawyers and developed in a way where I don't espouse the generalizations that are in that letter. And that doesn't reflect the person who I am today or the beliefs that I would bring to the bench should I be confirmed.
Okay. So you no longer regard Justice Thomas as someone who denies that racism is an obstacle?
Senator, as I said, I don't espouse the views in that letter now, and I also, as a judicial nominee, subject to the code of conduct for judges, I don't think it would be appropriate for me to comment specifically on Justice Thomas or speculate on his views or his beliefs. But at the time when I wrote that letter as a 20-year-old, those were my beliefs. And as I've said, those are not my beliefs. The letter does not reflect my current beliefs.
What about the contempt that you expressed for black conservatives in 1991? Do you still hold that view?
As I said, it's not reflective of my current views, and I would also say that to the extent that my personal views on any topic would not influence the decisions that I would be making should I be confirmed as a judge. I know it's critically important that judges don't bring personal beliefs to the judging act, and I am confident I would not do that.
Given your vast experience as a criminal defense attorney, are you confident in your ability to be objective in cases involving criminal prosecutions?
Thank you, Senator. I am. One of the tasks of being a criminal defender, public defender, is I've had to, over time, put aside my personal feelings about the case or the client or the issue, and I've had to put aside concern about public opinion or perception of the work that I'm doing. And so that experience of making the difficult decisions and putting aside personal beliefs is something that I've had to do. And I think in the context of criminal cases that would come before me, should I be a judge, to the extent that I have more experience than that, than perhaps some of the other judges, the beauty of the appellate process on the circuit and the fact that it's a collaborative process, I think is something that also ensures that many different views will be heard and that a fair hearing of the issue will occur.
Thank you. And thank you, Mr. Chairman.
Thank you, Senator Lee. Senator Coons.
Thank you, Chairman Durbin, and my thanks to both of you for your long service. It is inspiring to me to have such highly qualified and impressive candidates before us. Both of you have demonstrated a commitment to justice and fairness throughout your extraordinary legal careers. You would also bring greatly needed professional diversity to the circuit, the courts to which you've been nominated, given your long experience as public defenders. And I'm proud to support President Biden's commitment to diversity of all kinds, but in your case is particularly professional diversity. So I look forward to supporting your nominations. Ms. Lee, I was struck to learn that over 70 former federal prosecutors in New York, so the very people against whom you were litigating over and over and over in court, signed a letter in support of your confirmation. They called you brilliant and accomplished and said you are the right candidate at the right time for this important seat. Can you speak to how you've maintained mutual respect and collegiality with the very prosecutors against whom you were often in court, and how that approach will translate to your service as a judge on the Second Circuit?
Yes, thank you for the question, Senator. I think one important factor for me over my career that I've learned is that everyone is fulfilling their role in the system. You go up in court against another attorney who's representing the government, and it's about the role. They're supposed to do their best. We're supposed to do our best. It's not about, it's not personal. And I think that a lot of the attorneys who I've gone up against in court have recognized or realized that I also understand that, and that I'm serving an important role, and that we make vigorous and strong arguments against one another, but it's what the system requires. And so I think that the attorneys who I've appeared with and against respect that and understand that. And I think when you're dealing with other attorneys in a fair and open way, they do respond to that as well. And more broadly, in terms of prosecutors signing on and encouraging the appointment of someone with a public defender background, I think many of the attorneys in the criminal field in particular also understand the importance of balance and do respect the role of a public defender in the system. And so I think that's part of the reason for the support.
Well, thank you for that answer and for your conduct as a public defender that would lead to such a sterling letter of support from the very prosecutors against whom you were often in court. Ms. Rossman, you similarly received a letter from a broad range of over 90 members of the Colorado legal community. It includes former prosecutors, but also government attorneys and many others. And that letter describes you as having an abiding respect for your colleagues on the other side of the aisle in the courtroom, and a commitment to fairness and collegiality. I have the same question for you. Can you speak to how you developed this professional courtesy, this collegiality, and how would that bear on your service on the circuit court?
Thank you for that question, Senator. Again, I have to echo Ms. Lee. Everyone plays their role in this system, and in my experience, it has been a privilege and a collegial experience. The thing that I have recognized is that each represents their interests, but we are all officers of the court. And that informs our practice, that everything that each side does is done ethically, within the bounds of the rule of law, because doing it any other way wouldn't be appropriate, wouldn't advance the cause. And I've just found in my experience that it is one of mutual respect, even when it's a contentious case or contentious issue. And I think that that sort of mutual respect and professionalism is so important to the integrity of the legal profession, and it restores the public's faith, I would hope, in the justice system.
Ms. Rossman, Ms. Lee, as public defenders, part of your role is to be an advocate for your clients, to be an advocate for justice. But the role of a judge is distinct from the role of an advocate. Could you just take a moment and distinguish the difference in your mind between your service as a public defender and your service should you be confirmed as a judge on the circuit? Ms. Rossman first, then Ms. Lee.
Thank you, Senator. The roles could not be more different. The role of an advocate is nothing like the role of a judge, and I have reflected on this quite deeply. A judge needs to be neutral, impartial. An advocate proceeds within the rule of law, is also an officer of the court, but has a very different, focused objective. Over the course of my career, I have had a number of different roles that have required a number of different types of behavior and conduct and approaches. And I am confident that recognizing the difference between what an advocate does and what a judge does will serve me well if I'm confirmed.
Thank you. Ms. Lee?
Yes, I would echo what Ms. Rossman said about the importance and the distinct nature of the roles. And really, the only point I would add is that being a public defender for all of these years, I critically recognize the importance of a fair decision maker. That is the thing that all of the clients who I've represented over the years have wanted. And so I would take that duty to be that kind of decision maker incredibly serious, should I be so fortunate to be confirmed.
Thank you, Ms. Lee. Ms. Rossman, I appreciate your answers, and I look forward to supporting your nominations. Thank you, Mr. Chairman.
Thank you, Senator Coons. Senator Tillis.
Thank you, Mr. Chairman. Congratulations, Ms. Rossman and Ms. Lee, for being here, and to your, I'm sure, very proud family. Ms. Lee, one thing I want to say up front, I thought your answer to Senator Lee's question about being a 20-year-old, maybe your thoughts have changed over the years. I'd like for that to be the standard for all nominations hearings. I think that if you've stipulated that perhaps if you wrote today, you wouldn't have written the same thing, and I think it would be nice as we consider future judges and other nominees that we take that into account versus going to yearbooks and dumb text and letters and all the body of work that we're going to have when your daughter graduates from college. So be careful on the phone. Ms. Lee, I want to ask you a question. You were at a criminal defense lawyers, I think it was the New York State Association, and I think that the panel was crafting a persuasive statement of facts and argument, very important thing for a defense attorney to take into mind. You went on to submit notes and I think have some discussion about avoiding cop talk. Can you tell me a little bit about, what you were focused on there? I have a few points, but just to give me an idea of why that was important and what was discussed.
Thank you, Senator. It's been a while since I've looked at those specific notes.
It was 2013.
But I believe in that particular training, the suggestion is to not craft your brief in a way where you're just automatically using the language of the transcript or describing things in the way that perhaps that the police officers at trial testified. And so I think the suggestion it was making was when you are writing your statement of facts, don't just parrot what the witnesses at trial say. Try to present the facts in a way that most favorably describes the facts of the case and sets up the narrative for what you're doing on your brief and appeal.
Ms. Rossman, I know during the height of the COVID pandemic, you supported, as I do, compassionate release of prisoners, but you seem to take a position on a broader swath of those who were incarcerated. And we heard the chair talk about a number of statistics and the incidence of infections in the prisons. But if you dig below the surface, the incidence of infections in the broader community in certain at-risk populations were roughly the same as the prison population. So what was the rationale behind that focus on a broader swath of prisoners? The reason I ask the question is I really believe in criminal justice reform, did it as Speaker of the House when I was in North Carolina for early release. And I wonder sometimes if we go too far, if it could actually put efforts further back. So what was the rationale behind the broader release of prisoners?
Thank you, Senator. I guess I'd look at it a little bit differently. We didn't go into the work thinking that there was going to be necessarily an enormous flood of release. The compassionate release...
And I'm assuming they were nonviolent offenders that we were referring to?
Well, the compassionate release statute has certain criteria.
On compassionate release, I was talking to the broader population. Was it your opinion that that would be limited to nonviolent offenders, or...?
Well, that's the criminal history of the defendant certainly factored into the court's decision, but when we were making a decision about whether to pursue compassionate release, it was a multifaceted one. And we have a standing order of appointment in our district where we review every pro se compassionate release petition. It serves the court, obviously also serves the client. And we're looking first at eligibility. Is this someone who would satisfy the letter of the law before we turn to whether we file a motion that also advocates under the sentencing statute? And so the situation with COVID alone was not necessarily something that would satisfy the criteria for release. It was looking at the individual, which is what sentencing law does. It looks at the individual defendant. And in the case of compassionate release, it looks at it in terms of how the COVID pandemic, the situation within the Bureau of Prisons for that individual, it was always about the individual, whether that would merit a motion for release.
Okay, if I could just ask you all both to respond. I'm very concerned right now with what we're seeing in the law enforcement community. We've got a lot of brave men and women making split-second decisions, and there's a discussion about qualified immunity. So if you all could just very briefly, thank you for indulging me, Mr. Chair, just what do you think the proper scope of qualified immunity should be for men and women in law enforcement when being granted qualified immunity? Ms. Lee, we'll start with you.
Thank you, Senator. Certainly, I know that the topic of qualified immunity is one that many bodies, including this one, is looking at. As a judge, should I be confirmed, I'm bound by what the current law is, and the Supreme Court has upheld a standard for qualified immunity. And so that's what I would impose in terms of the policy considerations or whether or not it should be changed or modified in some way. Certainly that's not...
That's our job.
That is your job, and so...
Ms. Rossman.
Thank you, Senator. I agree with Ms. Lee. I'd say that law enforcement has a tremendously important and challenging job. If I'm confirmed as a circuit judge, I would follow the law of qualified immunity as developed by the Supreme Court in cases like Harlow and others, and the case law that's developed in the 10th Circuit. And with respect to any policy positions that may implicate the doctrine of qualified immunity as a doctrinal judicial matter, that would be outside the scope of what I would be concerned with as a judge if I'm confirmed.
Thank you. Thank you, Mr. Chair.
Thanks, Senator Tillis. We have a remote visit from the senator from New Jersey, Cory Booker. Can you hear us, Senator?
I hear you loud and clear. Can you hear me, Chairman?
Yes, we can. Proceed.
I'm really grateful, and I especially to Senator Lee and Senator Tillis. I thought that the thoughtful discussion about one of the nominees' background was handled the right way, and I think it is fair to ask people about their past writings, even if it goes back to college or high school. But as I think Senator Tillis just sounded, that it should be viewed within the totality of grace, of the understanding of grace, and that all of us evolve. I'd like to ask Ms. Lee a quick question. Ms. Lee.
We went to law school together.
Yeah, and if I had known back then of the potentiality for this moment, I would have really demanded that you share your notes with me back in because this is a great moment for me to an old friend. And I did not know you in college, but I will tell you this: I knew you as a law student. You were universally viewed by people of all different perspectives, and we had a highly charged intellectual environment back then. But you were one of these people that everybody saw that did walk with grace and had a extreme abundance of generosity of spirit to everybody you greeted. And I just want to give testimony to the fact that you are an extraordinary person in terms of your values. And what also was very impressive to me back then, you were an extraordinary person in terms of your brilliance. I got into probably Yale because they needed someone to help them win the intramural basketball championship. You got in there because of your extraordinary intellectual gifts. And so I'm excited that someone like you that I knew that there was not Senate hearings or a public spotlight, you are a kind and decent and gracious human being. And I cannot tell you how excited I am about your potentially sitting on the United States Federal Circuit. And so I just want to ask you, maybe to that spirit, we had conservative professors and we had more liberal professors. We had conservative classmates and more liberal classmates. You were someone that I thought was intellectually honest and open to different ideas. But we were in our 20s then, and I'm curious just for you to speak maybe to what maturity, what 20 years has done to your heart and your experience with serving in a capacity as a judge, to balancing differing views, differing ideals, and coming to what we want from our jurists, coming to analyze what's before you in a way that speaks to the highest values that I know my colleagues on both sides of the aisle hold dear.
Thank you for that question, and also for your kind words, Senator. One of the things I think that has had the biggest effect on how I've grown and developed as a person since being in my 20s has been representing clients. I have represented people from so many different walks of life, people whose views and values on a host of topics have often differed from mine. And when you are dealing with someone as a client, you're in a particular role, and your role is not to judge or to persuade someone to your point of view. It's to advocate zealously for them. And so being exposed to so many different people over my career, working with so many people, I've worked with a lot of pro bono attorneys at law firms, again, coming from a very different perspective than the one that I started with, and just dealing in the realm of criminal defense, where there are so many tough choices and so many different situations that you're confronted with. I think you do naturally grow as a person. And I think the fact that I've had so many opportunities and worked and dealt with so many different people in my career really has shaped who I am and shaped the views that I have on the world. The generalizations and assumptions that I had and that I made when I was younger, they don't exist in the same way. My views on life and the law are much more complicated and nuanced than they were. And so it's really been a learning experience and a growing experience over the last 30 years.
Well, my friend, I am thrilled, and I look forward to voting for both you and Ms. Rossman. But I will say this, as I look behind you, my mom would embarrass me during one of my recent campaigns by going around and telling people behind every successful child is an astonished parent. And she tells me I have astonished her. But I also know what James Baldwin said, that children are never good at listening to their elders, but they never fail to imitate them. I just want to say to your family behind you that when I knew you in our mid-20s, they raised an extraordinary human being who's lived a life that should make all of us. Your life and your commitment to serving others was evident in law school, and you have stayed in fierce allegiance to that. And it's a tribute to your parents, to your family, to your ancestors, and may God bless you both in your continued journey of helping our nation to live up to its ideals of justice for all.
Thank you.
Thank you, Senator Booker. Ms. Lee, I just say for those of us who work with Senator Booker on a daily basis, we too wish you would have shared your notes with him. Senator Hawley?
Thank you very much, Mr. Chairman. Thanks to the witnesses for being here. Congratulations on your nominations, your respective nominations. Mr. Rossman, if I could just start with you, I want to come back to the compassionate release topic that Senator Tillis was pursuing with you a minute ago, if I could. You wrote during the pandemic a great deal about compassionate release of inmates from jails and prisons, if I'm not mistaken. And I want to talk about first the case U.S. versus Wilson, which you might remember. That's where you sought compassionate release of a prisoner on the basis of his age. I think he was 58, had an underlying health condition, diabetes. He had been sentenced to 4 years in prison for being a felon possessing a firearm. He'd only been in prison, though, about a third of his sentence. The district court denied your motion. The court found that Mr. Wilson's criminal history and the circumstances of the instant offense suggest that he's a danger to the community. Here's what I ask you about. You wrote in your brief that the length of the prison term already served is not dispositive or disqualifying in the compassionate release analysis. And again, he'd only served less than a third of his term. So let me just ask you, Do you think that the length of term served, of the prison term served, is relevant in any way to the compassionate release analysis? Give us some indication of your thinking on this.
Thank you, Senator. Certainly the length of the term served is a factor. It is a multi-factor analysis, as all sentencing decisions are. They're individualized decisions where, especially in the compassionate release context, if the individual is eligible, and what that means in the context of that statute is that they've demonstrated an extraordinary and compelling circumstance warranting release, then the court needs to balance a number of sentencing factors, and certainly the amount of time that the individual has served is one of many.
In your view, is there a reasonable percentage of a sentence that ought to be completed before consideration of compassionate release or consideration for compassionate release?
Thank you, Senator. In the abstract, that's a difficult question to answer, and that's because these are such fact-specific inquiries that, again, the amount of time an individual has served, their custodial sentence, certainly a sentence has multiple components. There's a custodial component. There's also supervised release, which is part of the sentence. But the district court has the discretion in these cases to consider all of those factors.
But what about if, well, let's say the defendant only served a day? Would that be too little?
A day, perhaps might be too little, but certainly it would all be a very fact-specific inquiry. And I only hesitate to take a position on this because some of the cases that we were litigating in the compassionate release context involved individuals who were seriously ill and elderly. And so, again, because sentencing, as the Supreme Court has told us, is an individualized process, it's very difficult to answer those questions in the abstract.
Let me ask you about another case, the Moon case, United States versus Moon. You made a similar argument for the pretrial release of a 52-year-old individual male who'd been diagnosed, I think, with head and neck cancer. Now, what got Mr. Moon indicted in that case was his adult children reported that he was threatening them. The government's brief explained that when he was arrested, the defendant, the police found 12 firearms, multiple shotguns, multiple rifles, a loaded handgun underneath his pillow, a revolver, 2 self-made fully automatic machine guns. They also found 2 self-made silencers, a ballistics vest, and 4,602 rounds of ammunition. Neither the machine guns nor the silencers had serial numbers, making them untraceable. So this is somebody who had an arsenal, basically, in his home. We're seeing an epidemic of gun violence in this country. This is somebody who was ready to engage in such violence, and unfortunately also had a history of doing that. His criminal history included willful poisoning, witness-victim bribing, third-degree assault, and harassment. His children were placed in protective custody. Moon sent people to go after the children, and one of the people told Moon's roommates, those kids are done for. You argued Mr. Moon should have been released to home detention. I want to ask why you thought the risk of this repeat offender who is clearly dangerous, someone who is stockpiling illegal firearms, why would the danger to the community be outweighed by, in this case, health issues? I mean, give us a sense of how you balance this with a violent offender like Mr. Moon, who is engaged in all manner of violent, illegal activity.
Thank you for that question, Senator. I think that in the abstract, it might seem like there's absolutely no balancing to be done. But when we approach these cases, we're not asking the court to simply release an individual onto the streets. We don't even approach the court unless we have a release plan, something that we believe in good faith under the bounds of the law, we can bring to the court and say, here are terms and conditions that the probation department can weigh in on that we believe will satisfy all of the concerns, including the risks to the community. And in Mr. Moon's case in particular, he was suffering from terminal cancer. And at the time that he was arrested and so forth, his cancer treatment was interrupted. And the type of progression that he had, the concern was he would get much, much worse if his treatment wasn't immediately reinstated.
This is my last question, Mr. Chairman. But you, in the case of Mr. Moon, Ms. Rossman, you don't think that somebody like that poses severe danger to the community? A violent felon, someone who has an arsenal in his home, who is threatening his children, is hiring hitmen to go after them? I mean, help me understand why this person doesn't pose such a risk that you would say, sorry, I mean, you have a history here of violent felonies. We're just not going to release you.
Thank you, Senator. I understand the concern, and it's been a long time since I litigated that case, so I don't recall all of the specific facts that you're referencing. But I can assure you that I've never brought a case or an appeal or made an argument to a court that wasn't made in good faith according to the bounds of the law. And in Mr. Moon's case, it was no different. I applied the law that I thought was consistent with the position that I was advancing, and asked the court to do its job, which in this context is to exercise its discretion to weigh and balance the appropriate factors. And we didn't prevail in that case, but the argument was made in good faith.
Thank you, Mr. Chairman.
Thank you. I think Senator Kennedy is next.
Thank you, Mr. Chairman. Ms. Lee, congratulations. Do you think the United States Constitution should be interpreted according to how people understood it at the time it was adopted?
Thank you for the question, Senator. With regard to the interpretation of the Constitution, should I be confirmed as a circuit judge, I'll be bound by Supreme Court and Second Circuit precedent.
I know that, and I'm not going to ask either of you. I know you've been coached. The Trump White House coached the Republicans when they were nominated to always carefully say you're going to follow Supreme Court precedent. I stipulate that. I'm asking your opinion, your judicial philosophy, not how you're going to rule on a case. So let me rephrase it. Do you think the United States Constitution should be interpreted according to how people understood it at the time it was adopted?
Thank you, Senator. I don't have a personal judicial interpretation philosophy apart from what
you're going to be on the United States Court of Appeals if you're confirmed, and you don't have a judicial philosophy about how the United States Constitution should be interpreted?
Well, Senator, in terms of how it would be interpreted, I'm going to be bound by how others have said the circuits, the judges interpret it. And so...
Yeah, but we don't decide cases using algorithms and just take all the United States Supreme Court cases and put them in. And they haven't addressed every issue in the Supreme Court. Let me ask it again. Do you think the United States Constitution should be interpreted according to the way that people understood it at the time it was adopted? And if you don't, that's cool. Some don't. Many don't. How do you think it should be interpreted? It's a very simple question for a Court of Appeal nominee.
Well, thank you, Senator. I think the question actually is a little more complicated. The Supreme Court has...
No, it's not. It's about as basic as you can get. It's con law 101.
Thank
I'm not trying to be disrespectful, but... And I know both... You know, the thing now, but with all presidents, Republican and Democrat, is to coach the nominees. But you're going to be on the Court of Appeal, it confirmed, and I'm asking you, how do you interpret the Constitution?
I'm sorry.
I'm done. I'm sorry.
No, I'm sorry, Senator. No, I think certainly the interpretation of the Constitution has to start with the text. And to the extent that that's not to the extent that that's unambiguous, that's what we work with. But in terms of whether or not, when there's lack of clarity and there's a need to look to something else, I do think that, in fact, precedent gives us a lot of examples.
Let me try it again. The problem may be mine. The United States Constitution. Do you think it should be interpreted according to the way that people understood it at the time it was adopted, or another way?
I think there are many circumstances where it should be interpreted according to what people thought at the time it was adopted.
When?
Well, for instance, in the case of Heller, the Supreme Court applied original meaning to determine the scope of the Second Amendment right. And so
when shouldn't we apply original meaning?
I think when there are Supreme Court precedents that apply something, have applied something
on an original question.
I'm sorry.
When on a situation or a right or a privilege that, and I'm sorry to have to interrupt you, but we have so little time. Under what circumstances do we not interpret the Constitution according to the way that people understood it at the time it was adopted?
There are circumstances where the Supreme Court has not interpreted the Constitution explicitly in that fashion. And so I would always,
Give me an example. What example are you thinking about?
Well, there are times in the context of judging what is cruel and unusual punishment under the Eighth Amendment, where the Supreme Court has looked to...
That's a good example.
Look to prevailing norms in terms of interpreting...
Let me I got 15 seconds left. I'm sorry. Let me try it again. You get a constitutional case. There's no precedent on it. So you've got to interpret the Constitution. And I think I understand your testimony to be that sometimes we interpret the Constitution according to the way that people understood it at the time the Constitution was adopted, and sometimes we don't. How are you going to proceed? How are you going to decide which of those philosophies you're going to use on a particular case?
Thank you, Senator.
If there's no precedent.
I think that when there is not... I think the circumstances where there's not going to be either controlling or at the least instructive precedent from the Supreme Court or from the Second Circuit, I think is fairly rare. And so I can't say in the abstract, well, if this is the philosophy that I would apply, because again, I'd be driven by what the precedent says. And so I can't give you a specific judicial philosophy.
Okay. I'm way over. Listen, I'm going to send you both a letter. I can't vote for you if I don't know, and I didn't get a chance to talk to you, Ms. Rossman. I can't vote for you if I don't know what approach you're going to use to interpret the United States Constitution. And I don't believe for a second you both haven't thought about it. You couldn't have gotten through law school without thinking about it. So I need to know what you think about it. Okay? Thank you for your time. And I'm sorry I had to interrupt.
No.
Thank you, Senator Kennedy. Senator Cotton is online. Senator, can you speak?
Yes, I hear you, Mr. Chairman. Thank you. I want to thank the witnesses, too, for their appearances. Both of you have spent your careers as a criminal defense attorney. Have you ever represented a terrorist detained at Guantanamo Bay? We'll start, Ms. Rossman, with you.
No, Senator.
No, Senator.
Have you ever represented someone charged with a terrorism offense under federal law? Ms. Rossman?
I have not personally, no.
Ms. Lee?
No, I have not, Senator.
Okay, thank you. Ms. Lee, in a civil case in federal court, when do the parties have a right to a jury trial?
Thank you for that question, Senator. My practice has been primarily in criminal, and so I'm not familiar with all of the rules of civil procedure and in terms of entitlement to jury trials and the like. Certainly, though, I have experience, as I noted before, in terms of figuring out new issues when they've been presented to me and determining what the law is and how it applies to the particular circumstances.
So, Ms. Lee, I understand you've spent most of your career in criminal law, but this is a fairly basic question about when a civil litigant has a right to a jury trial. You don't have an answer to that question?
Thank you, Senator. No, I don't. I do not know what the requirement is or the rule is for entitlement to a jury trial in the civil context. As I said, I have a lot of experience in figuring out unfamiliar areas of law, and certainly when those are presented to me, I start with the specific claim being presented and work through the law and what I need to figure out to answer the question at issue.
Okay. The Seventh Amendment guarantees a right to trial by
jury in all cases where the value in controversy exceeds $20. How many jurors are there on a federal civil jury, Ms. Lee?
Thank you, Senator. My understanding is that in the context as well of a civil jury trial, that an individual is still entitled to 12 jurors. Although, as I said, I have not practiced in the civil context, and so the specific procedural rules, I have not had occasion to be familiarize myself with, I should say.
Okay. They're entitled to at least 6 and no more than 12. Can subject matter jurisdiction be waived in federal court, Ms. Lee?
Subject matter jurisdiction?
Yes.
I do not, thank you for the question, sir. I do not believe that subject matter jurisdiction can be waived. However, as I said, I have not practiced civil litigation.
That's right, it cannot be waived. For the purposes of determining diversity jurisdiction in a federal civil case, in what states is a corporation considered a citizen?
Thank you, Senator. I'm not positive about that. My understanding, well, I will say I'm not positive what the rules are on when a corporation can be considered. Do you say a citizen or a party to a...
Purposes of diversity jurisdiction.
Right.
Purposes of diversity jurisdiction, in which state is a corporation considered a citizen?
Correct. Okay. Thank you, Senator. No, I'm not. I cannot answer for you what the circumstances are for that.
The state where the corporation is incorporated and where it has its principal place of business. In a federal civil jury, each side is guaranteed at least 3 peremptory strikes. Can civil litigants remove potential jurors because they don't like their political beliefs?
Thank you, Senator. I am not positive on what the rules are on that. It does not present the same claim, the same issue, certainly in the criminal context where there are limitations on peremptory strikes, but I am not familiar with the rules for the jury service and use of peremptories in the civil context.
The answer is yes, they can. They can't use the strikes, of course, due to race or sex, though. Ms. Lee, you've said several times that you've spent your career in criminal practice, which I understand. However, you did work for 2 years as a law clerk in the federal courts where the caseload is more than 2/3 civil, and these are fairly basic questions of civil procedure. These are not obscure questions about, say, riparian rights. I'm surprised that you weren't prepared to answer these questions today. One of the most important moments in your professional career, and it raises concerns to me about what litigants should expect from you should you be confirmed at the level into oral arguments. I have some more questions, but my time is expired, so I'll yield back to the chairman.
Thank you, Senator Cotton. I believe Senator Blackburn is next.
Thank you, Mr. Chairman, and congratulations to each of you on being here today. Ms. Lee, I want to return to the question that Senator Tillis started with you on your 2013 comments to the Criminal Defense Lawyer CLE program.
Yes.
About avoiding cop talk. In the piece that I read on this, you said it was to avoid that because, and I'm quoting, this may refresh your memory, you made the mention that you had used this to most favorably describe an outcome that you were seeking. But in what I read, you said, and I'm quoting you, it legitimizes the behavior of the police, end quote. So what did you mean by that?
Thank you, Senator. I don't know if the portion of the document that you're reading, I'm not, without hearing what preceded it and what comes after it, it's difficult for me to respond specifically on that. I believe, though, that what I was, the point that I was trying to make with that was the idea by, again, parroting exactly how the witnesses or a police officer in a trial transcript described what occurred. By presenting it that way in your brief, you are accepting, well, this is what happened. This is the version of events that should be accepted, the judge on appeal should accept. And so as an advocate, we don't want to just present the facts in the way that supports what the witnesses are claiming. And so I believe that's what I was getting at with that description.
Would you review that and then submit an answer in writing for us? I think that would be helpful, especially as we look at the environment. Law enforcement is one of the main concerns. When I talk to Tennesseans, safe communities, safe streets, then to hear that you, as recently as 2013, would have said, avoid cop talk, and then state that it legitimizes the behavior of the police. I think you can understand why this would give us pause and why we would seek further clarification from you. So I would ask that you submit something in writing, that you review that and clarify it. Okay, Ms. Rossman, let me come to you. I like to know where someone stands with the Constitution and the rule of law. No one wants to see activist judges on the bench. They want them to abide by the rule of law. So same type question that Senator Kennedy got into it with Ms. Lee over, how do you believe the Constitution would be interpreted? Are you a textualist? What do you believe?
Thank you for that question, Senator. I don't have a specific judicial philosophy, and I think in part that's...
Well, I'm going to stop you right there because I find it astounding that neither of you have a judicial philosophy as to how you feel about the Constitution. Mr. Chairman, I think this is something that should cause all of us a little bit of concern. And let me return to the cases on the compassionate release. I read through some of this in your background. And the Wilson case, and then also specifically the Moon case that Senator Hawley was referring to. You know, if you think compassionate release should be used in the Wilson case, you argued that that Mr. Wilson being a felon in possession of a gun is a nonviolent gun possession offense, and that he should be released because of that and given compassionate release. And then you turn around with the Moon case and the threats, but you have not been able to explain where you think the court finds its balance. Each of these are violent offenders with felony records, but yet in your mind, you thought they deserved that release because of a health issue and without consideration of danger to the public and public safety. So it is very difficult to understand how you would approach that balance, and that is something that we would be well served if you could explain to us in writing how should the courts balance compel early release cases. Where would you find that? And I know I'm out of time, and I will yield back. Thank you, Mr. Chairman.
Thank you very much, Senator Blackburn. I thank the nominees for appearing before the committee. And please be mindful, as was noted, that some senators may submit written questions. We'd ask you to work diligently to respond to those. Thank you very much. And as they would say in court, you're excused. At this point, we're going to move to our second panel. I'd ask for everyone's patience for a few moments while we finalize the setup for this panel with the three nominees coming to the witness table. If you would approach the table and raise your right hand. Do you affirm that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that the three witnesses have answered in the affirmative. Judge Estudillo, did I pronounce that correctly? I've heard of 2 or 3 versions and I may have gotten it wrong. Is that correct, Estudillo? Sorry about these microphones, they're tricky. That's the first test before the Judiciary Committee. Phil, could you help with these crazy microphones? There we go. So we start off by saying, Judge, did I get your name right?
Yes, thank you, Senator Durbin. If I were speaking with my parents, it would be Estudillo.
Estudillo.
But everybody goes by or refers to me as Estudillo.
That sounded the same to me, so I'm going to stop right there.
There's a slight difference,
Please proceed with your opening statement.
Thank you, Senator. First, let me thank you, Chairman Durbin and Ranking Member Grassley, and the rest of the members of the committee here for allowing me to be here and to answer your questions. I also want to thank President Biden for the honor of this nomination. I am truly honored and humbled for even being considered for a possible judicial position. I want to thank my home state senators, Senators Murray and Senator Cantwell, for the trust they have placed in me in recommending me to President Biden. And I want to thank Senator Murray for her kind words this morning introducing myself. I also want to thank those members of the Judicial Selection Committee that forwarded my name to my home state senators. And I want to thank all of those colleagues, attorneys, friends, individuals that I've known throughout my life who have supported me and helped me in my career and my personal choices. I'd like to briefly recognize the family who has accompanied me here today. First, my spouse, Sandra, is right here next to me. She is my best friend and my confidant, and I don't know where I would be, quite frankly, without her today. I want to acknowledge my children, my oldest, Sophia, my daughter, Sara, and then my son, Sebastian, and doing their best to listen today and be attentive. I want to acknowledge my mother-in-law, Adelina Gonzalez, who is here as well, traveled with us to be with us here today and help out with the children. I also want to acknowledge my 9 siblings, although I will not give their names and their spouses' names, but they've all provided really good role modeling for me growing up, in particular my older siblings, as I am the 9th of 10 children, and the older ones were true role models for me. And lastly, I want to acknowledge my parents, Eloy and Esperanza Estudillo, who are no longer with us. It was their faith and their belief in the promises of the United States that gave my siblings and I the opportunity to live out the continuing chapters of their American dream. If it weren't for them, I don't know where I would be at this moment in time. Thank you again for listening, and I'm happy to answer your questions.
Thanks, Judge. Ms. King?
Thank you. Can you hear me?
Yes.
Thank you. I would like to thank Chairman Durbin, Ranking Member Grassley, and members of the committee for having this hearing today. I would also like to thank President Biden for the honor of this nomination, Senator Murray for the very kind introduction, and Senators Murray and Cantwell for recommending me to this important position of public trust. The fact that I am here today is a credit to the public servants who came before me. The first lawyer in my family was my great-grandfather, John Jacobs, who also served in the House of Kings and the House of Warriors in the Muskogee Nation government. My great-aunt, Irene Cleghorn, was the first woman to serve on the Muskogee Nation National Council. And my grandmother, Anna Jacobs, proudly served her country in the United States Army in the Korean War. There is a saying in Native America that we should devote our lives to protect and benefit the next 7 generations, and they certainly did. I have many others to thank for the amazing honor of being here today. I have spent my career surrounded by many inspiring attorneys, judges, and community leaders. The privilege of working with all of them has made me a better judge, a better attorney, and a better person. I would also like to acknowledge my family. With me today is my father, Jeff, my mother, Lisa, and my fiance, Sean. My stepmother, Sharon, my mother's partner, Henrik, my future parents-in-law, Susan and William, and my brothers, Michael, Tim, and Sam, could not be here today, but they're watching this hearing from home. I have many other members of my family and loved ones who also could not be here at this time, located all around this country and the world. I'm deeply grateful to them all for their support. I've struggled to find words, and in fact, I think there are none, to express how much my family means to me. They are the best part of me, and I would not be who I am or where I am today without their support. Thank you, and I look forward to answering your questions today.
Thank you very much, Ms. Lynn.
Is this on?
Now it is.
Thank you. I'm humbled, honored, and grateful to be sitting here before you today as a nominee for the Western District of Washington. I thank Senators Murray and Cantwell for recommending me to the White House and President Biden for the nomination. I also thank you, Senator Durbin and Ranking Member Grassley, as well as each member of this committee and your staff for taking time out of your very busy schedules to participate in this hearing. But this Chinese-American woman, immigrant, and first lawyer in her family would not be sitting here but for the sacrifices and support of so many. First, my parents, Chen Chao Lin and Yizhen Feng Lin, also known as Peter and Jane. My father came to America as a graduate student in 1966, shortly after the U.S. resumed admitting Chinese nationals. He decided to stay to give his daughters a better chance of success. And part of his dream came true when my older sister, Wendy Lin, became a doctor like we were all supposed to. But my father was unhappy with my decision to go to law school because he feared that the law was no place for an immigrant, someone whose first language was not English, and women. And it also knocked my younger sister, Betty Lynn Fisher, off track. She became a journalist for the Akron Beacon Journal, one of just a handful of Asian Americans with a regular column. My father passed 2 years ago, but I know that if he were here today, he would tell me that he's glad I didn't listen to him all those years ago, and that he's proud of me. My mother, who will be watching from Seattle, worked overtime shifts for years and sacrificed so much so that her daughters could go to college, an opportunity that she never had, and have a chance at a better life. I also thank my husband and children who are here with me today for lifting and inspiring me every single day. My husband of 28 years, Paul Holland, is a law professor at Seattle University School of Law, and he's the most amazing partner, father, and friend. My son, Patrick Holland Lynn, a 2019 Northwestern University graduate, is a chemistry teacher at a charter school in Chicago, and perhaps making up for my errant ways, an aspiring future doctor. My daughter, Julia Holland Lynn, is a rising junior at Annenberg School of Journalism at the University of Southern California. I also thank my big Chinese family, my husband's family, my friends and mentors for their love and support over the years. And finally, I thank my colleagues at Keller Rohrbach and my former colleagues at PDS, DOJ, the EEOC, and the Michigan Poverty Law Program, from whom I have learned so much and with whom I had the opportunity to do truly meaningful work. Thank you, Senators, and I look forward to answering your questions.
Thank you very much. I'm going to have a few questions. I want to make one observation from the previous panel. There was an effort by several of my colleagues to pin people down about their theory of the Constitution. And of course, that is a misleading question, or at least a dangerous question, because there are different people who put different labels on things and come to different conclusions. In fact, the nominees who were presented by the previous president avoided that question completely and came back with a standard answer that was given over and over again. I tend not to label myself because the term originalist or textualist may mean different things to different people. But obviously the preparation for the previous panel did not include that standard response. I encourage consistency from nominees of both political parties on that question and response. This is an amazing panel. When I look at your backgrounds and what you bring to this Judiciary Committee meeting and this court, I feel good about this country because each one of you has something affirmative to say about opportunity and also about a struggle that you or someone in your family has been through so that you could be here today. Judge, that your parents or grandparents were in the Lucero program. Ms. King, that your background with Native Americans, I was amazed as you talked about generations in the Muskogee Nation and their leadership in that regard. And Ms. Lynn, as an Asian coming to this country, I know that you struggled many times, your family did, with prejudice. And yet, despite all those things, here you sit today, taking an oath and aspiring to serve in the federal judiciary. It's a great testimony to our nation that we've been able to overcome some of the prejudice of our past, and that you, with your determination, come before us. Ms. Lynn, you immigrated to the U.S. from Taiwan at the age of 3, initially settling with your parents in Kansas and later moving to Chicago. You didn't speak English until age 5, is that correct? And your family faced some prejudice as you were growing up. How did your childhood and immigration experience factor into your decision to become a civil rights lawyer?
You know, it factored greatly into my decision to try and help others that were in my situation. As you stated, Senator Durbin, I did not speak English when I first started school, and so my earliest memory really is of the teacher who thought I wasn't listening to her because I didn't understand what she was saying, pointing at me and telling me to put my head on my desk. So I spent most of my first year in school with my head on the desk, not because I was disobeying her, but I didn't listen to her. You know, another deeply formative experience for me was when my parents moved us to the suburbs, someplace where they thought it would be safer because there was a lot of gun violence in the neighborhood that we were living in. But we were one of the first families of color. And along with that came apparently, you know, the inability to use swings, because I remember being on a swing when a much larger girl came up and shoved me off, yelled an expletive, and asked why I thought I could use it. And the principal, when I was sent to the office, asked me what I had done to provoke the girl, and I was sent home. And those experiences were deeply formative for me. You know, and I've also watched my parents. My mom, everything about her is about helping others. My father and his dreamers. So service and helping and doing good has been the bedrock of sort of my upbringing.
Ms. King, it appears that you have come from two different worlds, the regular world of law as we have learned it, many of us, and the world of intertribal law and custom. How have you been able to reconcile those in your mind?
Thank you, Chairman. In my 8 years of experience as an appellate judge on the Northwest Intertribal Court System, it's been a very valuable experience because that system serves over 20 member tribes. So when I'm assigned to a new case, I have to familiarize myself with the new sovereign's code and constitution. It's helped me keep an open mind and at the same time contributed to faithful adherence to the law because I'm working within a different system every time.
Judge Estudillo, I'm sure I'm mispronouncing your name again, but you know what I'm trying to do and to be respectful of you. As you hear conversations about immigration and the Hispanic population in America and reflect on your own family story, how does it affect your role or how you envision your role as judge?
Thank you, Senator, for the question. My parents' immigration story is both unique but the same as many other immigrants that have arrived here in the United States and sought a better life. And I recognize that. So when people come in front of me, I'm open-minded about different backgrounds, different histories, et cetera. And I want to make sure I have an inclusive environment in everything that I do. Because I recognize people are different. You don't have to be an immigrant to be different. Sometimes people are just different than you. And you need to be open-minded about people's differences and be willing to work with everyone. And that is an approach I take with me every single day on the bench.
Thank you. Senator Grassley.
Yeah. My first question is to Ms. Lynn to see if there's some consistency in her position. In 2017, you wrote a letter to Sessions about Trump's rhetoric towards Judge Robart in Seattle. You said Trump's efforts, quote, to publicly vilify individual judges was wholly inappropriate assault on the independence of the judicial branch. Last week, San Diego Judge Roger Benitez, who is a Latino immigrant, issued an opinion striking down California's AR-15 ban. The governor of California called the opinion, quote, a disgusting slap in the face to those who lost loved ones to gun violence, and, further quoting, a direct threat to public safety and innocent Californians. One prominent liberal commentator called Judge Benitez quote, a death worshipping fascist, while a liberal law professor called it, quote, a diatribe disguised as a judicial opinion. Now, you don't have to agree with this opinion, but those statements, including by the governor of California, go beyond disagreement. Given what you said in 2017, do you condemn these attacks by Judge Benitez as inappropriate assaults on judicial independence?
Senator, I would note that I didn't write the letter. I did sign on to the letter along with thousands of other attorneys. And the reason I signed on to the letter is because I think that the impartiality and independence of the judiciary is a bedrock, again, of our judicial system. And so I think comments that attack judges for just doing their job aren't helpful. And I think, as Judge Gorsuch said during his confirmation, are disheartening and demoralizing.
You have been very involved with the ACLU, including at a leadership level. A recent article in the New York Times cataloged how the ACLU seems to be abandoning its traditional role as a protector of free speech, regardless of its content. The article says, quote, some ACLU lawyers and staff members argue that the First Amendment is more often a tool of powerful than the oppressed, end of quote. Do you agree with that statement?
Your Honor, Senator, I understand that there was a New York Times article about the ACLU, and I would note that I'm involved with the ACLU of the organization. I believe that free speech is a fundamental right that is important to be protected.
The article goes on to say in 2018, the ACLU, quote, unfurled new guidelines that suggested lawyers should balance taking a free speech case representing right-wing groups because such a case might give offense to marginalized groups, end of quote. Did you agree with these guidelines when they were set out? And if not, what did you do from your leadership position to oppose them?
Senator, I believe that article was talking about the ACLU National, and so I'm not familiar with the guidelines that were issued there because, again, I am a member of an affiliate board.
I might ask you to respond in writing to further that discussion because I think that's pretty basic to how things would be. I've got one question for Ms. King. I've received lots of letters supporting you from Native American tribes. You obviously have an impressive support within that community. In some ways, it's a mirror image of what happened when Eric Miller was nominated for the Ninth Circuit. At that time, I got countless letters from tribes opposing him. While I appreciated their perspectives, I thought the arguments against Miller was pretty unfair, namely that because he frequently litigated against tribes, he'd be biased as a judge. I think our legal system works best when both sides of the case are well represented, including Indian law cases, and we should evaluate nominees based on their records more than their clients. What do you think?
Thank you, Senator, for that question. I know and respect Judge Miller, and he was certainly a zealous advocate who took very seriously his obligation to be the voice of his clients. As a judge, he takes very seriously his oath to be the voice of the law, and if I were so fortunate as to be confirmed, I would do the same.
Okay. I yield. I'll submit a question to Judge E. Later on.
Senator Blumenthal.
Thanks, Mr. Chairman. Thank all of you for your service already to our nation and to your state of Washington, and your willingness to serve in this very important position. I'm tremendously impressed by your qualifications and experience. You will bring to the bench really a lifetime of service in our courts with a very detailed knowledge about what fairness looks like in our legal system at a time when the rule of law and norms that underlie our judicial system are very much under challenge. You also bring diversity to our system. As the chairman has remarked, President Biden has really, in his nominees so far, demonstrated the importance of diversity in our judicial system. But I would be interested in all of your views, maybe beginning with Judge King and Ms. Lynn, because if confirmed, you will be respectively the first Native American federal judge in the Western District of Washington, and Ms. Lynn, you will be the first Asian American appointed to either of Washington's judicial districts. What you see the value and importance of diversity being in our judicial system, if you could comment.
Thank you, Senator. I believe diversity of all kinds is very important to the federal judiciary. I believe that it improves public confidence, and it also serves an important modeling function. So everybody who might aspire to be public servants is aware that this path is open to them. With respect to Washington in particular, as Senator Murray mentioned at the outset, there are 29 federally recognized tribes in the state, and to my knowledge, we've not had a federal judge in the Western District with a background in Indian law, so I believe that my unique background in that area of the law will serve me well if I'm so fortunate as to be confirmed. Thank you.
Thank you. Ms. Lynn?
I echo what Ms. King said about diversity increasing public confidence. And as far as role modeling, I would say that, in my nearly 30 years of practice, I haven't yet had the pleasure of appearing before somebody that looks like me. And I was thinking about applying for this job and looking into the past judges to learn that there had not yet been an Asian American because, according to the last census, in King County alone, 20% of the population is made up of AAPI people. So I certainly hope that if I am lucky enough to be confirmed, as Ms. King said, it will be, it will demonstrate that the bench is open to people of all different backgrounds. And for me personally, and given my personal story, I certainly hope that it will also assure or reassure some immigrant parents that the law is an honorable and good profession for their children, especially their daughters.
Thank you. Judge Estudillo, if you have any comment, I'd welcome it.
Yes, thank you, Senator. I'll just be brief. I do agree with the public confidence aspect that diversity brings, as well as the role modeling. And just to add on the role modeling, I regularly meet with young individuals or students in the juvenile court system, and many of them are from Latino backgrounds and whose parents also work in the fields. And even though I don't know if I can truly change their thoughts and what they're doing in some of the decisions they've been making, I've tried to use that role modeling in front of them and say, hey, look, there are opportunities if you just are willing to try. Your parents are here to help you, and the juvenile justice system is here to help you as well. And I hope that at some point I'm able to at least inspire one of those students or individuals in the juvenile justice system to make better decisions. And that's my hope anyway.
Thank you. Thank you all. Thanks, Mr. Chairman.
Senator Lee.
Ms. Lynn, I'd like to start with you. A moment ago, one of my colleagues referenced a letter that you signed from a group called DOJ Alumni. I'd like to refer to another letter you signed with that group about a year ago. And in that letter, you condemned the Department of Justice's decision to dismiss charges against General Michael Flynn. And in that same letter, you also urged District Court Judge Emmett Sullivan to, quote, closely examine the department's stated rationale for dismissing charges and to deny the motion and proceed with sentencing if appropriate. Is this an appropriate thing? Is it a proper role for an Article III judge to determine whether a criminal prosecution should proceed after the government has sought dismissal?
I think as a matter of the checks and balances, it is the role of the judge to look at the specific, I'm not saying always, but it would really depend on the specific facts of the case, as well as the arguments put forth by the parties.
Ms. King, I want to turn next to you. In 2016, you opposed a proposal that would have prohibited religious practices at Washington State Bar events. You argued that an opening blessing or ceremony before or after an event was an inherent and normal part of Native American culture, and that blaming religious practices was inconsistent with principles of diversity, equality, and cultural understanding. He also quoted the Supreme Court's holding that such practices are, quote, deeply embedded in the history and tradition of this country. Ms. King, I just wanted to applaud you for those statements. I think they're spot on. Can you explain to us briefly why it's vital that we be willing to respect religious freedom and religious expression in the public square?
Thank you, Senator. I take freedom of religion very seriously. I think it's no coincidence that freedom of religion is included in the very first of our amendments in the Bill of Rights. And the arguments that we put forth in that letter were consistent with the Supreme Court holding in Marsh v. Chambers, I believe.
No, in 2018, you gave a presentation that described arguments based on the plain meaning of a treaty's text as, quote, ethnocentric. Could you explain how arguments based on plain meaning of a legal text could be considered ethnocentric?
Thank you, Senator, for that question. I don't recall making that argument. I believe you're referring to the United States v. Washington case where our task was to prove on behalf of our client the meaning of a treaty term in 1855. The strongest evidence and the evidence that we relied upon was from treaty time.
Okay. Yeah, this was you presented in that presentation, so these were your words, not mine. I wasn't sure what you meant by ethnocentric. So you wouldn't regard that as a wrong thing to do, to look to the text of a legal document being interpreted by the court. And this, getting back to some questions asked earlier today with other nominees, without regard to whether you call yourself a textualist or originalist, if people are uncomfortable using those, that's surprising to me, given that this focus is on the text. Let me just ask it this way. Is it the case that courts should look at the text of a statute and look to ascertain the understanding at the time of enactment or adoption into the Constitution of those words and how they're understood at the time?
Thank you, Senator. The text of a statute is certainly the most probative evidence of legislative intent. With respect to the Constitution, though...
It's the most probative evidence. So if it's the most probative evidence, what other evidence could there be? I mean, isn't that your job, is to figure out what is said? How do you ascertain the collective and how do you ascertain the subjective intent of anyone and everyone? Don't we view that by looking at the text?
The analysis starts with the text, and if the text is clear and unambiguous, your task is generally done. I would look to text, statutory context, apply the canons of construction if needed, and if needed, could also look to legislative intent for legislative history.
Ms. Lynn, do you share that view?
I do.
And Mr. Estudillo?
Yes, I agree.
Great. These are questions that I believe are not remarkable. They're not controversial, given that it is the job of the judicial branch of government to say what the law is, as Hamilton explained it in Federalist 78, or to decide cases and controversies using the language of Article 3 of the Constitution, meaning when multiple parties come together and they disagree as to what the law says, and it's a matter before the jurisdiction of the court has to decide what that means. And in defining that, it's important for us to know how jurists will approach that task. And I'm pleased to hear that each of you would be driven by the text in that analysis. Thank you.
Thanks, Senator Lee. Before I adjourn today's hearing, I want to enter a number of letters into the record and make a few logistical notes. We've received letters of support for today's nominees from across political, professional, and ideological spectra. These include letters of support from national civil rights organizations, federal prosecutors, and law enforcement, support from numerous Native American tribes and tribal groups. They'll all be entered into the record without objection. Now, questions for the record that may be directed toward the nominees will be due to the nominees by 5 p.m. on Wednesday, June 16th. The record will likewise remain open until that time to submit letters and similar materials. And with that, this hearing is adjourned.
Thank you, Senator.